Good afternoon, everyone. We could probably spend the next 3 days instead of the next 30 minutes talking about this topic. So I am just going to be scratching the surface for you of some of the things that I think are important to know as business owners. You're in a unique industry, certainly in the adult use marijuana industry. But if you're operating an establishment or a cultivation facility or anything else, and you have people working for you, then you're an employer, and the employment laws that are out there that apply to businesses generally are going to apply to you also. The workplace is probably more regulated than you think, and especially as a company grows. We have laws at the federal level and regulations we have at the state level, and sometimes even at the local level. And unfortunately, in the startup world for small employers, these kinds of things and human resources generally can get overlooked or just regarded as less important when you're trying to get the business itself off the ground. This is usually a mistake. You need to take care of your people and look out for compliance issues. It only takes one disgruntled employee to cause a problem for you. And in the employment world, those problems are investigations by government agencies and audits, even lawsuits, which are a huge distraction for you from running your business and can be costly both in terms of legal fees and possible fines or damages. So you don't want to mess with employment disputes. And I would encourage you to take compliance seriously as you're getting your business off the ground. You'll probably hear me say this more than once in the next 30 minutes, but I also would encourage you to partner with either an experienced HR professional or an outside company like a payroll company that also offers HR support. They can be invaluable for people who are trying to focus on the business because they can take care of some of the more nitty-gritty issues related to both pay and general HR compliance. So one of the first issues that I see causing problems in the employment world is startup businesses that bring everyone on or maybe bring their short-term workers on as independent contractors and do not classify them as employees. This seems like a good strategy because it's usually a lot simpler than hiring an employee, and it can be less costly. And those are often the reasons that that strategy is used. But it's also quite risky. Government agencies have an interest in ensuring that workers are properly classified. Why? Follow the money. Taxes are a big issue. So the IRS is interested in making sure that people are properly classified as either workers or contractors. For employees, you have to pay payroll taxes, and it has to be withheld from their check. There's Social Security and Medicare taxes, income taxes withheld. None of that applies when you have someone as a contractor. So if someone is misclassified, the government's not getting that money. Similarly, at the state level, the Department of Economic Security, unemployment insurance tax is supposed to be withheld from wages, which are paid to employees. The Industrial Commission requires that you have workers' compensation insurance for employees, but not for contractors. The federal and state departments of labor, again, are interested not only in taxes, but in ensuring that people are paid at least minimum wage and overtime when it's applicable. Contractors aren't entitled to either minimum wage or overtime. So all of these government agencies have an interest in this issue. Unfortunately, I can't draw a bright line for you or give you a single test that says someone's a contractor or an employee. There's a whole host of factors that go into that. The most important one is the behavioral factors, and that is, do you as the company have the right to direct or control how the person does the work? Do you tell them what to do? Do you tell them where and when to do it? Do you tell them how to do it? The more you're doing that, or the more you have the right to do that, the more likely the person is as an employee. And another big element there is whether the person that's doing the work is doing a key part of your business. If you have people working in the establishment or in the cultivation facility, that's the key part of your business. That's what you're doing. It's very unlikely those people are going to be properly classified as contractors. Who sets the hours of work? Again, if it's you, more likely an employee. The contractors are more likely to set their own hours. There's also financial factors that go into that. Who sets the rates? Does the person invoice you? The contractors often issue invoices and set their own fees and rates. Does the worker provide their own insurance and their own licenses, their registrations, certifications they might need? And then other factors. Is there a written contract? Does this person have their own business? Are they a separate LLC, for example? So there's lots of factors that play into this. Government would also look at, do you treat them as an employee? Do you give them business cards? Do they have office space? Do they have a company email address? Did you have them fill out the hiring paperwork that employees fill out? So the more that you treat someone like an employee, the more likely it is they are an employee. So big issue, and misclassification can be costly, both in terms of pay and overtime issues and also the tax issues that we talked about. Here's another thing to consider at hiring. Is your employee at will? And I've put these two terms up here because I often hear people confuse the two terms of at will and right to work. The right to work refers to the ability of employees at a unionized workplace to not join a union. That's really probably not going to be important to you. But at will employment is. And that means either the employee or the employer can end the relationship at any time for whatever reason, no reason, and with or without notice. That is the presumed state of employment here in Arizona by statute, and that is likely what most of your workers are going to be. We are both at will and right to work, but the at will concept is going to be the most key for you. Here's another consideration at hiring and during employment. Is your employee exempt or non-exempt? This term applies under the Federal Fair Labor Standards Act, and we'll talk a little bit about that in just a minute, which governs overtime and minimum wage. But non-exempt employees are eligible for overtime pay, and that's going to be most of your employees. Exempt employees are not eligible for overtime, but there's criteria to be exempt, and that includes having duties that make the person exempt, and I've listed the most common exemptions there, which are executive, administrative, and professional. And then the individual also has to be paid a fixed salary that meets a certain level, and it's currently $684 a week. I hear a lot of people make the mistake of just calling someone salaried and thinking that they're exempt. That is not the case. It has to meet both the duties test and the salary test. You can pay a non-exempt employee a salary, and they're still going to be eligible for overtime because they don't have the duties that move them to that exempt level. You're going to need some documentation at hiring. So for most employees, we recommend including an offer letter, and that would include the key terms of what they're being hired for, the position, when they're starting, if there's any conditions or contingencies on hiring. For example, in your industry, that might include background check, fingerprint check. So you're going to make their hiring conditional on passing those things. You're going to include the pay. You want to include whether, overtime eligibility, bonus eligibility, and kind of a description of your benefit and time off plans. And then relevant to the at-will concept we just talked about, the offer letter, assuming this is true for the person, should state that their position is at will. Another kind of documentation that we recommend thinking about for all employees is business protection agreements. Sometimes it's referred to as a non-compete or a restrictive covenant agreement. Sometimes it's a confidentiality agreement. Those are the kinds of terms that we recommend considering putting in there, particularly confidentiality, which is something that you can more readily apply to all of your staff and protect your most confidential business information about your vendors and your contracts, and other business relationships that you have. For key employees, you may want to consider having agreements that restrict what they can do after they leave, whether that's not soliciting away your other employees, not soliciting away your customers, your vendors, or interfering with your business, and in some cases, possibly a non-compete provision. Those can be tricky to enforce, and I would definitely recommend consulting a lawyer before you try to do that. Another kind of documentation that you can consider having for, we'd say, more higher level or leadership positions is an actual employment contract. That would include, again, key terms of compensation and salary, and particularly if you're considering giving someone equity in the business or particular incentives based on performance or severance pay when they leave. Those are not common terms of employment for your average member of the workforce. So that's the kind of thing that we often see put into an employment agreement. And I've listed some other key terms there that you would see in an agreement, including the duration, and then the same kind of business protection provisions that I was just discussing for the regular workforce. You'll certainly want to have that for the higher level people as well. And for everyone at hiring, by federal law, you are required to complete an I-9 form for all employees that establishes their authorization to work in the United States. You've probably all completed one of those at some point in your life for whatever job you had, because it's a requirement of every employer. In addition, in Arizona, we have a state law requirement to use the E-Verify system, which is a federal system that helps verify that someone is eligible to work in the United States. So once you get the business set up, that's another thing that a payroll company can help with, or a PEO, but enrolling in E-Verify so you can check people's authorization to work will be another startup process for you. So that's the hiring. Let's talk about what happens when people are actually working for you. So I mentioned the Fair Labor Standards Act earlier. That's the federal law that establishes minimum wage and overtime requirements for non-exempt employees. Overtime pay is 1.5 times someone's regular hourly rate for more than 40 hours worked in 1 week. And so you, as the employer, are going to have to establish a fixed 7-day week that is your work week or your payroll week. It can be any 7-day period. You just can't manipulate it and change it around to try to avoid overtime obligations. So if you want it to be Wednesday to Tuesday, that's fine. It does not have to be a Monday through Sunday. There is no requirement at the federal level to give people meal and rest breaks except for nursing mothers, but depending on the length of the break, you may have to pay. Generally 15 minutes or less, those are paid breaks. The federal law doesn't require you to provide vacation pay or sick time or holiday pay or severance pay. It doesn't even mention those terms. So those are all a matter of company policy, except for the sick time, which we'll talk about in a minute. There are, under this statute, a whole lot of regulations about what does and doesn't count towards paid work time. And it's a really easy area for even well-meaning employers to trip up on. So, for example, travel time, on-call time, training time, time in meetings, taking on and off specialized equipment and gear. All of those things and more are the subject of federal regulations or court decisions about when the time has to be paid and when it doesn't. So again, having competent HR or legal help to address some of those trickier issues can be key for ensuring compliance. Under both federal and we'll talk about state law in a minute, you have important record-keeping obligations as the employer. The most important record you need to keep is accurate records of people's time worked. And this is important for non-exempt employees for overtime eligibility. You have the obligation under the statute to keep these records. If they are not in existence or if they are inaccurate, this can present big problems if the Department of Labor conducts an audit or if someone files a lawsuit claiming that they're overtime eligible. So I can't emphasize enough having those records. There's not a prescribed form. Some employers still use paper and charts, spreadsheets. You can do it electronically. There are apps that help people keep track of their work time, even with geofencing, where people can't log in for their work shift until they're within a certain distance of the facility, and can't log in or out within a certain number of minutes. So there's lots of technology out there that can help with that as well. You might also tie it into your point of sale system, depending on what's existent in the establishment. I would also recommend employees certify the accuracy of the hours they submit. Why do you want to do that? It makes it a lot harder later for someone to claim that, oh, I actually worked 5 more hours that week than I put on my timesheet, if they certified the accuracy at the time. The other thing I would say is do not let any managers or supervisors encourage people to work before or after their shift without clocking in, or work through unpaid meal times. This is referred to often as off-the-clock work. This is also a big problem. Lots of lawsuits on this issue, and you don't want them to ignore it or tolerate it if they know it's happening. Big risk area. Finally, there's a minimum wage notice that has to be posted in the workplace. As you'll hear me mention notice posting a couple of other times. All of these things are available for free on the internet, but I would recommend that you connect with, again, like a payroll company or an agency that can provide you with, for a pretty modest cost, a combined set of posters. The laminated thing you may have seen in a break room at another workplace that has 20 different posters on it. Very handy, saves a lot of time in trying to, pull them off the internet, and it's a very modest investment, usually around $50. All right. Arizona has some of its own wage and hour laws. We have a state minimum wage law. It's currently $12.15 an hour, but on January 1st, it's going to go to $12.80. That's much higher than the federal minimum, so we need to comply with the state minimum. Flagstaff is even higher at 15. Again, like the federal law, we don't have rules regarding breaks or meal periods. We also don't have an overtime law, so we follow the federal law here. And I've listed there some of the other topics that the Arizona wage statutes cover. A lot of it concerns how and when people get paid. So it defines wages, which includes bonuses or commissions, other things that employees have a reasonable expectation of being paid. It establishes permissible withholdings from pay. There are certain circumstances in which you can withhold from people's pay for legally required things like taxes, things they authorize, like insurance premiums, and then if there's a reasonable good faith dispute about whether something is owed. And then the statutes require you to have regular pay days. They govern the timing of when people have to be paid when they leave, and they provide for the possibility of triple damages if someone's wages are wrongfully withheld. And like the federal law, there are also record retention obligations and a notice posting obligation. We in Arizona have a paid sick time law that's been in effect since 2017. It's called the Fair Wages and Healthy Families Act. And every employer is covered by this law if you have even one employee. So the accrual rate is at least 1 hour of sick time for every 30 hours of work, or you can give everyone all of the time they get for a year at once. Depending on the size of the company in terms of how many employees you have, it's either 24 or 40 hours per year that someone is eligible for. If you have 15 or more employees, you're covered by that 40 hours. Smaller employers are the 24 hours. There are certain prescribed uses for sick time that are spelled out in the statute, and it includes not just the employee's own illness, but someone in their immediate family, as well as public health reasons, like we're currently experiencing, and domestic violence and sexual assault reasons, including court appearances, are covered. There are some documentation restrictions under the statute. There are specific pay stub information requirements. All of that stuff is easy to trip up on. So again, either legal help or competent HR help can help you with your compliance there. There are also very strong anti-retaliation provisions in that statute. So you don't want to be taking action against someone for using their sick time in a bona fide way. What other laws do you need to know about when you're an employer? We have some major civil rights laws at both the federal and state level. The big one is Title VII. That's at the federal level, and that prohibits discrimination on the basis of race, color, national origin, religion, and sex. We have the Americans with Disabilities Act, which prohibits discrimination based upon disability or a record of disability, or even someone who's regarded as disabled. And it also requires that you provide reasonable accommodation for people who have disabilities unless it causes undue hardship. That statute is definitely a seminar unto itself. And so if you have disability issues, medical issues, definitely consult with an HR professional or a lawyer for how to handle those. They can be the trickiest things you will face. We also have an age discrimination statute that prohibits discrimination against employees who are 40 and older. And there are some special rules in that statute related to severance and release agreements if you're asking folks 40 and older to sign one of those. Again, you'll want to get legal help to make sure you do that correctly. And then in Arizona, we have our own companion statute to all of these. It generally covers the same ground, except that it hits smaller employers with regard to the prohibition on sexual harassment. So Title VII, the age discrimination law, Title VII and the ADA, those cover employers with 15 or more employees. The age discrimination law comes in when you have 20 employees. The Arizona Civil Rights Act is at 15, but the sexual harassment provision applies even if you have 1 employee. So you're going to need a sexual harassment policy, which we'll talk about in a second. Under all of these laws, again, you've heard these words, you're going to have record-keeping obligations and notice posting requirements. All of them prohibit retaliation for either opposing conduct that's prohibited by the law or participating in a complaint procedure. They are enforced by federal and state agencies and the courts. And I've listed out the kinds of remedies there, not just monetary remedies. People can seek reinstatement, and prevailing plaintiffs can also get their attorney's fees, meaning if you get sued and the person who sues you wins, you will pay not only your own fees, but theirs. So you can see how these disputes can get expensive very quickly. So what do you need to do? Definitely have an equal employment opportunity policy and an ADA reasonable accommodation policy. You're going to want to have a policy prohibiting sexual harassment and other unlawful forms of harassment. All of the categories that I mentioned is covered under Title VII. Harassment is also prohibited on those bases. And then take it seriously and make sure your staff knows that the company takes it seriously. And one way you can show that is by having a complaint and an investigation procedure and making sure that you have at least 2 avenues for people to complain. There are plenty of examples of cases out there where someone said, I didn't complain because it said I had to go to my supervisor and my supervisor was the problem, he was the harasser. Okay, the courts are not going to find that that's an effective policy. And as I've said before, if you have sticky issues, call an HR professional, call a lawyer, do it before it turns into a legal dispute. You've heard the cliche, an ounce of prevention is worth a pound of cure. It is absolutely true in the employment world. We definitely appreciate when our clients contact us with issues before they turn into lawsuits, and because we work on trying to prevent that from happening. A couple of other laws you should know about. The National Labor Relations Act. This is often thought of as applying only in the unionized context, but it actually applies to all employers. And it does give non-supervisory employees certain rights. The biggest one listed there is the other concerted activities for purposes of mutual aid and protection. What does that mean? That means employees can band together and raise issues about their pay, their hours, their working conditions, and that is considered protected by law. And so the employer cannot take action against employees for raising those issues. That's considered a form of retaliation under the law. We see this come up a lot on social media posts where one employee will make a comment that sounds like it's complaining on behalf of the group, and other people pile on with their comments, their likes. This is a real danger area, and it's something that the National Labor Relations Board, which is the agency that enforces this law, is very interested in. This is not a statute you want to mess with. The board that enforces it is currently quite favorable to employees. And they work very fast when they get complaints. It's a big headache for employers. So again, this is another area where it's easy to trip up and make a mistake, and I encourage getting HR assistance and legal assistance if you think you want to fire someone for raising a complaint about one of these issues. Safety is another area you need to be concerned about. I mentioned workers' comp insurance earlier. That's a requirement in Arizona. For all employers, you must have either an insurance policy or be self-insured for workers' compensation. That is something you can get on your own, but also a a professional employer organization or a payroll company can often help with that, and it can be very cost effective for smaller employers to work with an organization like that. The other major agency in this area is the Occupational Safety and Health Administration, which enforces the Occupational Safety and Health Act. You as an employer have a general duty to provide a workplace that's free from recognized hazards that are causing or likely to cause death or serious harm. This has come up quite a bit in the pandemic era, and employees have raised lots of safety complaints, both at the state level and the federal level, with regard to the safety of their workplaces. So again, as with the other statutes, there are record keeping and reporting obligations. There are anti-retaliation provisions that protect employees who raise issues. So take your safety obligations seriously. Don't get mad, don't get even when people raise issues. Finally, let me just touch on policies and handbooks and why you should consider having each of these. Your policies, which are either in a manual or in an employee handbook, tell everyone what the standards and expectations are for your workplace. And it forces you to think about what they are, which is good for you as an employer. And it also can be evidence that you've taken compliance with your legal obligations seriously. So I've listed out there a number of policies that we recommend having in the workplace and publishing as part of a handbook or on an intranet, however you decide is going to be the most effective way to inform your workforce of what your policies are and what your standards are. And with that, I will take some questions.